5 seconds to go. Start. The High Court in the impugned judgment erred in holding that the appellant had not examined the author of the documents. Such reasoning is absolutely erroneous, as in the written statement the respondents had not denied their signatures on the documents referred to by the appellant, but pleaded duress in executing of these larger number of documents. The witness examined by respondent number 1 in his cross examination admitted his signature or that of the representative of company on invoices, debit notes and on ST1 form. The respondent had led no evidence in respect of fraud or duress apart from self-serving statement. The consignment of goods was sent from the month of November 1985 to January 1986. The respondent had signed large number of documents during this period. However, no complaint was made to any person or authority or even to the plaintiff. It is a denial of receipt of goods without any basis raised only in the written statement filed. Such stand is wholly barren of any truth and is thus rejected. The debit notes stamped and signed by the respondents were in respect of trade discount on the wholesale price mentioned in the invoice. Having accepted the trade discount, which is evident from the stamp and signatures not only on the debit notes but also on the invoice as well as on ST1 form, shows that the goods were actually lifted by the respondents for which payment has not been made. The respondents have taken up wholly untenable ground that the documents were signed under duress. Large number of documents such as invoices, debit notes and ST1 form spread over 3 months is unbelievable to be an exercise of duress. The stand of the respondents is wholly untenable and unjustifiable in law and is only to defeat the legitimate claim raised by the appellant. The High Court in the appeal has gravely erred in setting aside the reasoned order of the learned single bench on the grounds which were not even raised by the respondents. In view of the said fact, the order of the division bench of the High Court dated 28th May 2012 is set aside. Conditions subject to which a dealer may claim deduction from his turnover on account of sales to registered dealers. A dealer who wishes to deduct from his turnover the amount in respect of sales on the ground that he is entitled to make such deduction under the provisions of subclause 5 of clause A of subsection 2 of section 4 shall produce copies of the relevant cash memos or bills according at the sales are cash sales or sales on credit, and a declaration in form ST1 duly filled in and signed by the purchasing dealer or a person authorized by him in writing. Stop.